When discussing technology regulation, and in particular the issue of robot companions, one very relevant question that policymakers and society at large often asks is that of liability, in particular civil liability. That entails questioning whether the autonomy certain machines display suffices to hold them responsible for the damages they may cause during their functioning. The issue is quite complex on various grounds, including theoretical but also practical ones. On a theoretical level, affirming that a machine might be held liable entails acknowledging the machine as a living and autonomous being that is capable of forming its own intentions and act accordingly in order to pursue them. On a practical ground, holding the machine liable entails shielding other subjects, human subjects in particular, the producer, the business user, or even the final user, from the negative consequences associated with the functioning of the device in the very first place. However, an attentive legal and ethical and also technological analysis allows us to radically exclude that that might be the case, meaning that there are no ontological grounds, nor technical grounds, and much less so legal grounds to consider a machine a living being deserving rights and subject therefore also to liabilities. Machines are plainly objects, things created by human intelligence, artifacts that are or could be extremely useful and also display some degree of autonomy. However, that degree of autonomy does not suffice as of today to consider those machines as strongly autonomous, so sentient beings that are capable of forming their own preferences and act accordingly. Therefore, we can radically exclude on ontological grounds based on these very simple technical and philosophical considerations that machines may be deemed subjects and therefore agents and also responsible for the negative consequences deriving from their functioning. The degree of unpredictability or unforeseeability of certain of their outcomes associated with their function does not suffice to consider them agents. Eventually, they are sophisticated tools, objects, products, and should be treated as such. This does not entail stating that nothing needs to be done with respect to liability rules. Indeed, there might be grounds to consider that those machines ought to be regulated with some specific set of norms. That also entails, eventually, new approaches that reform or revise the existing framework at European and national level. The current framework is fundamentally based on the Product Liability Directive. That is a directive dating back to 1985, adopted by the European Union. And this directive is now currently being considered for revision. There are grounds to consider that there is indeed a need to reform that body of norms. And that could also be done in a way that we have identified and elaborated throughout the project and other research initiatives, many of which funded by the European Union, that is called the risk management approach. The risk management approach focuses much less so on who is to be blamed for the negative consequences arising from the use of a given technology, and much more on which party is best positioned to identify the risk, manage it, and eventually insure against it. Very often that party will be the producer. Other times it will be the operator, so the business user of the technology that provides services using it. Even if those parties were held liable, however, that would not entail that those parties would be equally or entirely burdened with the negative consequences arising from the use of the technology. Very often, price mechanisms will allow those parties to transfer such costs to all the user of technologies that are actually purchasing it or purchasing services that adopt the given technology. So, for instance, a manufacturer, if held responsible entirely for the consequences arising from the use of its device, might purchase insurance, and that would build into the cost functions uh, that he has to consider for delivering the given service, delivering the given product. And ultimately, that will be embedded in its final resale price. So whomever buys the technology is also purchasing at the same time an insurance covering all damages that might arise from the use of that very technology. In case of an accident, if the producer were bound to compensate such damage, then he would resort to the insurance mechanism and be shielded from the direct economic consequences of that liability through the insurance that he would have purchased. But ultimately, the one that would have paid for the insurance are all those that purchased the good or service, therefore spreading the cost among all potential users. In such a perspective, however, simplifying liability rules would ease the position of manufacturers that would be able to avoid substantial litigation, and also victims that would more confidently buy those more advanced technologies, as opposed to being left with uncertainty with respect to whom would be eventually held responsible for the damages they might suffer in case an accident nonetheless occurred.
Depending on how they're framed, and in particular on their content and the time and level at which they are adopted, legal rules may enable and support technological development, or on the contrary, they may constitute an obstacle for it. And the latter happens in particular when regulation is too broad in its scope and requirements, as it may prove an ineffective way of guiding behaviors and may even be disregarded. To avoid that, traditional top-down hard law, which is often framed in general and broad terms, may be complemented with soft law instruments and transnational private regulation, such as standards and codes of conduct, which are more easily drafted in detailed and narrow tailored terms, and can also be more easily adapted to technological and market developments. Indeed, this complementarity between hard law and soft law has been taken into account by policymakers, and in particular by the European Parliament, which made a case for it in its 2017 recommendation on civil law rules for robotics and AI. Yet, at a more practical level, soft law and transnational private regulation need to be carefully drafted to reap the benefits that they carry as a particular modes of governance, while at the same time avoiding any possible problem or shortcoming that might be associated to them. With technical standardization, industries representatives and technical experts, as well as societal stakeholders, develop commonly agreed technical specification for manufacturing and marketing products and services. And as such, it represents a very effective method of integrating scientific expertise into regulatory meaningful decision-making processes. However, private standardization bodies select technical model which will eventually achieve a quasi-regulatory role, but those modes are not just technical in nature. They very often affect highly sensitive areas such as consumer protection, environmental protection, health, safety, security, etc. And because of that, standardization ends up involving or representing a sort of policy-making discretion made outside public institutional settings. So against this context, Public oversight and careful inclusions of all the stakeholders affected is of fundamental importance. Indeed, the European standardization system constitutes a very virtuous example in this sense, but it still suffers from some shortcomings. In particular, the participation of societal actors in standard setting is very often hindered by resource and expertise asymmetries, and this may result in poor investigation into the societal context in which standardized technologies will concretely operate. But as robots enter into our living and working environments, filling this gap becomes of fundamental importance. Thus, our research highlighted that reliance on soft law and transnational private regulation needs to meet certain conditions in order to be acceptable and effective, and ultimately to allow the development of legally and ethically relevant standards for the European robotics industry. In particular, expert and standardization professional must have or gain a complete and sound understanding of the specific legal significance of the technologies to be standardized. And it's also necessary to develop a smooth integration of legal expertise in standard setting processes. And finally, by default, regulation must be framed in a way that makes it compatible with the overall judicial system in which those standardized technology will operate in. And in particular, it is important to avoid that the very high complex technical nature of those technologies ultimately covers the possible legal and societal biases, subtracting them from judicial review.
An additional part of the research focused on, analyzed and addressed the ethical impacts and ethical initiatives related to robot companions, since the diffusion of robotic applications and their proliferation is dependent upon said applications' ethical impacts assessment. Against this background, the working group addressed first the extant ethical assessment approaches for the identification of existing and emerging ethical concerns by taking into account relevant EU-adopted policy initiatives. In particular, the research addressed the cornerstone policy-making instrument on technologies ethics, namely the Ethics Guidelines for Trustworthy AI of the High-Level Expert Group on AI, published on April 2019. The guidelines have immediate bearing in the field of AI-based robotic applications devoted to human interaction, as they require said applications to be human-centered and to respect fundamental rights as stated under the EU Charter of Fundamental Rights, and they must be compliant with the ethical principles of respect for human autonomy, prevention of harm, fairness, and explicability. Second, the research addressed one of the specific questions still left untouched by policy in the policy debate, that is trust and deception in human-robot interaction, which is of paramount importance in the field of robot companions. To do so, the research provided a description of the relevant technologies, that is robot companions, and of the reasons why they may give rise to deceptive practices. It showed that deception can arise as companion robots are often designed to simulate empathy and intelligence effectively, which may trigger emotions in humans, although robots and appliances are equally inanimate and aware of their very existence and deprived of any intention. The risk of deception is especially present when companion robots are used by private parties, such as for elderly care and child care, which are among the most vulnerable categories of persons. Certain companion robots, through autonomy and goal-oriented movement, their responsiveness in the environment, their capacity to provide feedback in the form of sound, movement, and light, the more they are being engaged with, may manipulate inherent human reward mechanisms and trigger the vulnerable users into falsely believing that a meaningful relationship may be developed with said robots, possibly leading in the end to loss of dignity and psychological disappointment and misunderstanding of what a meaningful relationship is. Said risks, if they materialize, will have a tremendous negative bearing on the functioning of the society at large, which is directly dependent upon the well-being of its members. As more and more robot companions are being placed into the market, this also raises the question whether users should have a free choice on using said robots based on the principle of freedom of self-determination. In this respect, the working group argued that the principle of freedom of self-determination can encounter a limit in the principle of human dignity, intended in an objective and external fashion. That is, when the use might violate the human dignity of all humans, not only the users. Therefore, dignity, understood as a constitutionally protected value, should not be transformed in the value one could dispose of. Based on the above, the research showed that the use and diffusion of companion robots should be subject to regulatory and ethical oversight by taking into account all societal consequences and risks, including the ones that may affect and hinder the dignity of the individual in question and of others.